Hi, my name is Alan Palange, Executive Director of the law firm. I wanted to talk to you for a moment about the statute of limitations. This is very well a bit of information that most Americans truly don't understand. And today, in our example, I'll be talking about credit card debt. So as an example, if you live in the state of Delaware, and each state has a different level or a different time frame for the statute of limitations. But if you live, as an example, in Delaware, and you have a credit card that was issued to you while you were in residence in Delaware, the statute of limitations would be 3 years. Now what that means is that if you have a credit card debt that you've defaulted on, and it's run the statute, meaning it's gone longer than a 3-year period, then the courts in Delaware no longer, or any court for that matter, no longer has jurisdiction to hear the case. Now what that means in simple terms is you cannot be sued. So oftentimes we'll get a phone call and somebody will tell me that they feel that they may be outside of the statute of limitations, but that the collector continues to call looking to collect the money, as well as has filed a lawsuit. So the mere fact that something is run the statute doesn't in and of itself prohibit somebody from filing a lawsuit. However, in a very simple motion, we would be able to get that particular lawsuit kicked out of court because it is what we call a time-barred debt, or in the business we call it a zombie debt, and it is a debt that has run the statute of limitations. Now keep in mind that from the date of default, this item should remain on your credit report for up to 7 years. But again, if it's run the statute of limitations, it is beyond the reach of any kind of litigation. Now, the one thing you do have to remember is when these creditors or third-party collection companies file lawsuits, they realize that 80% of the time, most Americans don't respond to the suit. So even if your debt is beyond the statute of limitations, or if it's not, and you do not respond to that initial complaint, and you normally have 20 days in which to respond, the opposing side, the plaintiff, would be able to march into court and get a default judgment on your case, or in your case. Now once they have a default judgment, it becomes very much a challenge to be able to overturn that judgment subsequent to it being issued and adjudicated by the judge, by the court. So keep in mind that many of these lawsuits, whether they're filed from the original creditor or from a third-party collection company or a third-party firm that has purchased the debt, they realize that, again, 80% of the time, people will not respond to the lawsuit. If you don't respond to the lawsuit, then they will march in and get a default judgment, which complicates everything tremendously. So my first bit of advice is, if you have been served, please reach out to local counsel and be represented and make sure that you respond to the lawsuit within the given 20 days. Also keep in mind, if you have debt that's been now outside of run its course and it's outside of the statute of limitations, keep that in mind as a bit of leverage that you now have depending on what you want to do with that debt. If you have any additional questions about your particular jurisdiction, your state, and how that works with the statute of limitations, please call in and speak with one of our paralegals or consultants. Again, my name is Alan Palange, Executive Director of the law firm. Thank you.